Hi, everyone. Thank you for joining the Life Hacks webinar today. Our topic is financial planning for life's uncertainties. We've got a diverse audience joining us. Of the over 100 registrations that we received for this event, we had batches spanning 1986 to 2019. So a very sort of a broad spectrum of people joining, different life stages, and I'm sure they will have different sort of financial questions and concerns. Given the background of our audience, we also expect that many would want to know about financial planning tools for assets in different jurisdictions. In that sense, we have a vast ground to cover. So to make good use of the next 1 hour efficiently and comprehensively, we will start with a moderated session, about 30 to 40 minutes, and will then open up for Q&A. So if you have any questions, please use the Q&A feature on your Zoom screens, and we will take them up after the moderated session. Before I introduce our panelists, I also just quickly wanted to say thank you to the Tann IIMA Association for sharing their Zoom infrastructure with us and making this webinar possible. And I hope we don't have any internet glitches over the next 1 hour. We will, of course, be covering, the broad spectrum, as I said. So we will be touching upon wills, trusts, nominations, LPA, AMD, and all the other questions that you have. So let's get started soon. Our panelists for today are Reena Chew and Rajah. Reena heads the wealth planning team for Bank of Singapore, South Asia and ASEAN. She's been with the Bank of Singapore for since 2016, and she's been working with private clients for succession planning and wealth transfer matters for the last 15 years. Vikna heads tax and trust and private client practices at Rajah and Tann. Prior to joining Rajah and Tann, Vikna was senior legal specialist with IRAS. And I'm happy to say that the private wealth practice that he heads has been ranked Tier 1 by Legal 500 Asia Pacific in 2019. Before we begin our moderated session, I'm going to invite Reena and then Vikna to say a few words to introduce our session. So, Reena, over to you.
Thank you. Thank you so much for having us today. I think the idea of today is really to give everyone an overview of the succession tools that we feel are important, especially in today's day and age. And hope to cover as much ground as possible today. And of course, if anywhere we've missed out in the moderated session, we hope that everyone will give their questions freely and we try to address them. And hopefully we are able to answer everybody's questions by the end of this session.
Good morning, ladies and gentlemen. I think, as Veena mentioned, we are here to give you an overview. And on top of that, I think it's a good opportunity for those of you who may not have had the time previously to think about your succession planning tools and ideas, to encourage you to do think about it, right? Now, this is to give you two examples. Earlier this year, the founder of one of South Korea's largest companies, Lotte, passed away without leaving a will, right? And the same thing happened in 2002 in relation to, of course, Mukesh and Anil's father as well, when he passed away at the relatively young age of 69. So what we have seen is, especially for very successful individuals, there's a little bit of sense of invincibility sometimes. And because of that, they may not give sufficient thought to their succession planning needs. So we really would like you to, after the session, at the very minimum, take some time to ensure that you've got your bases covered. Thank you.
Thanks, Vikna. That is really very important because our audience includes a number of people, including people who worked in the financial services industry And yet it isn't uncommon to be sort of unprepared or underprepared for many of life's uncertainties. And I think this is that opportunity to sort of bust some of the myths and misconceptions about planning for the future and sort of getting started promptly. I will begin with a moderated session now. I'm going to open up with a very broad question. Rina, that's for you. Could you just, provide us an overview of the common forms of wealth transfer available in Singapore? I know there are a number of them available to our audience, but just to set the stage, if you could just take us through the common forms.
Sure. So we believe that I would say the forms of transfer doesn't only have to happen after your lifetime. You can choose to do so even during your lifetime. And the most common form is actually gifts that's made to your lifetime, in your lifetime. It's not uncommon whereby we see parents basically sponsoring the first car or first property or insurance for their children. We see grandparents bequesting for their grandchildren educational funds as well. So therefore, gifts is actually the most common form of wealth transfer during your lifetime, considering there's no gift tax in Singapore. It is very common as well that between husbands and wives that there is a joint account in place. And the idea of it is just to put in place a provision that if one doesn't survive, it goes to the survivor, and that the survivor should have the means to basically have access to the funds. I think one of the areas whereby it's been stressed a lot about, but maybe people have not given any time to do it or to think about it, is really to do a CPF nomination. So we do stress for all our clients that are based in Singapore to do a very simple CPF nomination. It's available online. You just have to go to the CPF website and you're able to do a nomination. And I think that is something that if you have time today, that should be something that you look at today itself. The next few items we feel that are items that people should look at. It is to address succession after your lifetime. Okay. One is, of course, simply put, you should have a will in place. Okay, there should not be any ambiguity in terms of who receives your assets and who's given what. So a properly drafted will is very important because you don't know what will happen tomorrow. Okay. If you have liquidity needs in your family because you have taken out a mortgage, or if you have school-going children, you need to make sure that there's a safety net for them to have liquidity immediately to address your liability. Or if you're running a company that is taking out loans to finance its day-to-day operations. The other item that we think that people do not look at it enough is the concept of insurance. Getting sufficient insurance to cover yourself to ensure that your liquidity needs are met is actually very important. So I do feel that people should look at insurance. And of course, if you have been very successful in your life and you build out a very nice nest egg, the last item that we feel that people should look at is really to set up a trust. A properly administered and managed trust would ensure the longevity of the assets that you've built, create their legacy, asset protection, as well as to maintain a certain level of confidentiality. And we hope to be able to cover all this in detail in the next few questions.
Thanks, Rina. So we talked about gifts, joint accounts, the CPF nomination, wills, insurance, and trusts.
Yes.
I'm going to take up wills as the first question. I'm going to address it to Vikna. Vikna, could you provide us an overview of, what's a will and what's the process for making it in Singapore?
Sure. So I think most of our audience will know that a will is an instrument which is executed in order to determine how your assets pass when you're no longer around. From a validity perspective in Singapore, of course, it requires someone who is mentally competent to execute it. And you'll be surprised at the number of instances where we've had challenges on mental capacity. So if a person is of an elderly age, it makes sense to also get a doctor's certificate to confirm that person is mentally competent. It has to also be witnessed by at least 2 persons who are not beneficiaries, right? So that's key. Now, one of the considerations is that if someone passes away without making a will, it is actually down to, at least from a Singapore perspective, it's down to intestacy that then determines how the assets are distributed. And that process generally takes significantly longer than the probate process under will. And the assets may not be distributed in the manner which you would prefer. So just to give you an example, if you have a spouse and children, under Singapore law, half of it goes to the spouse, half of it goes to the children, and no provision is made at all for your parents, which may not actually be what you had intended. Further, if a will is made before contemplation of marriage, it is automatically revoked upon marriage. So that is another thing to bear in mind.
So you talked about intestacy. Could you elaborate a little bit more about what happens in different situations in the event one does not have a will? Because from what I understand, in Singapore, a large proportion of working age population, in fact, does not have a will, may not even have an estate plan. So I think the number based on research is probably less than 20% have any of these sort of planning tools. So could you elaborate on what exactly happens, in the case one doesn't have it?
Sure. So essentially, your closest relatives would have to make an application to CON for what you call letters of administration. There may be guarantees as well, which they would have to put up. And it's a process which would generally take at least twice as long as the pure extraction of probate if a will was done. So one of the downsides is it's a longer process. Secondly, as I mentioned before, generally there may be a higher scope for dispute because the method of distribution would be what is stipulated in the Interstate Act. And I've previously given you a scenario as to what would happen. So for example, if you have a spouse, but you have no kids, then half goes to the spouse, half goes to your parents. And essentially each scenario is determined in accordance to statute and not what you may have actually intended.
I'm going to talk a little bit about jointly owned assets, because I guess that's a simple way of transferring assets. But within that category, there could be a variety of different assets, and joint ownership of various kinds. So this question is to the both of you. If you could, just comment on the process of transfer of jointly owned assets, and how does that work in Singapore?
So I'm going to touch on the ownership of joint account holders, and in the event if one of the account holder doesn't survive, what happens in that scenario? Okay, and I think a lot doesn't realize that the terms and conditions of how your joint account is governed is very dependent on what you have signed up when you open the account. There is a misconception that, well, if I have a joint account, then in the event if something happens to me, it would definitely go straight and automatically to the surviving joint account holder. that's not really the case. So therefore, we do urge people to speak to their banks to confirm that in the event if something does happen to them, that the surviving account holder would have immediate right to the account. They do not need to wait for a probate process to be completed, and that the surviving account holder should be able to have access to the funds immediately. Now, over in Bank of Singapore, that's the terms and conditions of our account opening, that in the event if one doesn't survive, it does go to the survivor, and the survivor will be able to transfer the assets immediately to their own individual account. Okay. Now, when we talk about joint ownership in terms of property assets, this is a very common scenario, and I'll pass that baton to Vigna for him to answer that question from a legal standpoint.
Thanks, Rina. Just to pick up from where Rina left off. In the situation where there's a joint account, right, there has been litigation that essentially the joint account holder was there essentially just to help access funds, but the beneficiary of the account was always, for example, if you have a parent and daughter, the daughter was given access to the account, but solely to help fund the parent's activities and not for, say, the son's or daughter's own benefit. So in that sort of situation, the other siblings may contest that that particular child is not solely entitled to the funds in a joint account. So that's the tricky part, which is why Rina said, that has to be clarified. The general position in law is there are two methods in which you can hold property, right, jointly. So the first is as joint tenants, and the second is tenants in common. If it's a joint tenant situation, the property automatically passes to the surviving joint tenant. If it's tenants in common, the property passes according to each party's wills. Now, whatever you state in a will cannot sever a joint tenancy. So a joint tenancy, if the intention is to sever it, it has to be done in writing, it has to be done before a person passes away. However, it is useful to deal with all your joint accounts in your will, because even if it's a joint tenancy account, you would have to provide for the situation where you're the last surviving account holder, and how that those assets should then be passed on to the next generation, or however you please.
Okay, I'm going to cover just a couple more questions, and then we've got a large number of questions from the audience. I would like to move to them as well. But just to cover some of the basics before we get into audience questions, Rina, could you give us the overview of a trust, and how does a trust versus a will versus a joint account stack up? What are the pros and cons?
Sure. So let me just share with you a slide. So if you look at the definition of a trust, essentially, this is the definition which is shown on the slide. But simply put, a trust is basically a contract whereby you've put an obligation on the person who's called a trustee to deal with your assets, and basically to tell the person that in the event if something happens to you, then how should those assets be dealt with, okay? So in essence, a trust is a contractual relationship. In Singapore, there are legislation that governs how a trust should be managed. There is also legislation that governs what are the duties of the trustees, and it put a very high level of fiduciary duty on the trustees to make sure that the obligation is fulfilled in an appropriate manner. Okay. Now, earlier we've touched on joint account, and Vigna touched upon what are some of the shortfalls that we've seen so far in the public domain in terms of a joint account, which is the fact that, number one, depending on terms and conditions of the with your bank, it may not automatically go to the survivor. Number two, it may be litigated if the intention was that the surviving account holder was to hold for the benefit of the family rather than for them oneself. Okay. So the reality of the matter is that we're not saying that a joint account is insufficient. A joint account, in many a times, from a practical perspective, it is required because you need to be able to have an arrangement in terms of how it's dealt with in terms of your expenditure account, for example. Okay. So whether it's a trust, a will, or a joint account, we do feel that in reality, you may actually need all three to help you in terms of your planning objectives. Okay. When it comes to a will, it is a legal document. It has to be properly drafted. You should review it on a regular basis to make sure that your intentions and your wishes continue to be reflective in what is stated in your will. However, in recent times, if you look at what has happened, a will is a public document. It is subject to challenge, and the executor of your estate, which is essentially your family members, have to go through a legal process, which we call a probate, in order to have access to your assets. So having a will is not good enough. You need to go through a probate process before your family members can have access to your assets, which means during the meantime, before the probate process is completed, your assets are essentially frozen and your family will have no access to the assets. And therefore, if they have ongoing expenditure, they would have to see for themselves that they have sufficient liquidity to meet that obligation. Okay. So if we compare trust versus a will, the difference is effectively the need for a probate. Okay. If you look at the situation of using a will, the scenario that would happen in the event if you passed on will be very much that's what's highlighted in blue. Okay. Your appointed executor will have to notify people about your demise. Your assets are going to be frozen. And if you have assets all over the world, this becomes even more complicated because the probate process would then have to travel around the world. Okay. And your executor will obviously have to pay any outstanding debts, taxes, before your beneficiaries have access to your assets. Okay. So if you think about Singapore in general, assuming that there's no challenge to your will, okay, this process is on a first come, first served basis. So it could take easily 6 months, 9 months, assuming that there's no claims, there's no challenge, okay? But if you have assets globally, this process would have to repeat itself in the other countries. And depending on the legislation system in the other countries, it may get even more complicated. But with a trust, what happens in a trust is that during your lifetime, what you've done is you have actually transferred the legal ownership of your assets from yourself to your trustees. Therefore, when you passed on, the assets do not form part of your estate. Your trustees already know how these assets are to be dealt with. They do not need to go through a probate process. Your assets will not be frozen, and your beneficiaries would have immediate access to the assets that's held under the trust. So if we look at from a very practical example, we do generally suggest to clients that you should consider setting up a trust to cover your liquid assets, things like your investment account, your life insurance, that should be under a trust. And immovable assets like property, whereby there isn't an urgency to transfer that to your beneficiaries, you can choose to cover that in your will, together with other assets of value like your jewelry, watches, and bags. So that can be in a will, but your trust should cover your main liquid assets. So if you look at it, we do see that joint accounts, wills, trusts, they all work together. If you plan it and structure it properly, it could be a very seamless way of ensuring that your succession needs are met.
I'll just add on one point that, so in addition to what Rina has mentioned, I'll just add secrecy. Yeah. So
Yes.
a will is a public document. If you Google, you'll be able to find, for example, Princess Diana's will. Right. A trust actually adds that layer of security because of the fiduciary duties that the trustees have in relation to keep the trust and letter of wishes highly confidential. So even in instances where information has to be provided in relation to the trust, the letter of wishes are not disclosed.
Okay. I really would, I think Rina briefly touched upon that multi-country, multi-jurisdictional assets, and I can see a lot of questions on that. But before moving to the audience questions, there is one last point I would like to touch upon. So this question is for Vikna. There are a lot of misconceptions and myths around what is a living will. What's a lasting power of attorney? What's an AMD in Singapore? So perhaps if you could just spend a few minutes and tell us, just kind of demystify these terms for us, and then we will move to the audience questions.
Sure. Yes, I noticed a number of people asking about living will. So a living will is essentially what we would call advanced medical directive. So that deals with the situation where whether or not you would want to have life-sustaining treatment in a situation where your chances of recovery are minimal or none, right? So this comes about when, of course, you are incapacitated and are unable to make those decisions yourself. So that's the advanced medical directive, or living will, which deals with life-sustaining treatment. In relation to lasting power of attorneys, this deals with the situation where you're still alive, but you're incapable of making decisions in relation to your finances and personal welfare. So you would appoint people to take over these decision making for you, and you can actually appoint different people for different tasks. So, for example, if you think your daughter is more suitable to make decisions in relation to your personal welfare, you can appoint her, and you can appoint someone else to then make decisions in relation to your finances. So that's the lasting power of attorney.
Okay, thank you. So we're going to go now to the audience Q&A. And there are a number of questions around multi-country assets and how they can be sort of planned for. So I'm going to take the first question. Can a will in Singapore cover assets in other countries? Or do we need wills for all countries where assets are?
Can I take this, Rina?
Sure.
Yeah? Yes, okay. I think maybe Vikna, you can also cover off in terms of even if we have a will in various countries, does that mean that we would, how would the probate process work in terms of having to do it at different jurisdictions? So I think there's multiple countries, multiple questions of the same nature in relation to will. So maybe we'll just cover that off and then we can close off a few questions.
Okay, so what happens is a will in Singapore is you are able to get it resealed in other jurisdictions, right? But that resealment process may take more time than if you had a will in that other jurisdiction. It depends. So what we usually recommend, and on top of that, different jurisdictions, especially in relation to immovable property or land, may have specific requirements as to how those assets are transferred in those respective jurisdictions. So although in law you can have one will governing multiple jurisdictions, our recommendation is that if you have significant immovable property in a foreign jurisdiction, you should have a separate will in that jurisdiction.
Okay. There was another question, a related question, which was, is a will registered in India valid in Singapore for all the Singapore assets? I think your answer is that we should have wills in different countries covering the different assets. That makes sense. Okay. There are a few questions around the point of trusts. Particularly the threshold required for a trust. It's a common understanding, and I think may not be necessarily a wrong understanding, that a trust typically is suitable beyond a certain AUM threshold. So could you comment on that?
So personally, we don't think that there is a threshold for setting up the trust. The reality is that you can set up a trust to hold any value of assets as long as you view it as valuable. The more practical view of it is that there's a cost in setting up a trust because you need to pay your trustees for providing that service to you. So it's a question of whether that asset of value justifies that cost and ongoing cost of maintaining the trust. We as trust practitioners, we do obviously encourage clients to actually have a very honest conversation with their trustees to understand what are the responsibility that's covered under the trust fee. In today's day and age, I would say that the trust industry is very competitive, and it's really to understand the terms and conditions that govern your trust relationship and the fees. And in the event, if let's say you do set up a trust and your trustees and yourself is not working out, the good thing about the trust is that you can always change the trustees because it's a fiduciary relationship. It's a service that's provided. You can always change the service provider that is offering you the trust services. So I think there's a misconception that once you set up a trust, that's it, you're stuck, you're with the trustees, you can't move and so on and so forth. But that's not true. In today's day and age, you can change your trustees. You can choose to terminate the trust if you don't feel that you need any more. There's a lot of flexibility in it. But I think you need to speak to the right people to get the right answer. So of course, at any point in time after this conversation, if there's more in-depth discussion in terms of an individual's needs, we're happy to have that conversation.
Okay. Just if I could just chip in a little bit there, right? Just to give you some flavor from what we see. So in terms of, Rina, please correct me if I'm wrong, in terms of minimum annual trustee fees, right? I think you're looking at something around US 5,000 or so if it's extremely simple trust with purely financial instruments, right? And of course, once you add in non-financial instruments, that cost goes up and it can go up quite significantly.
That's
so
correct.
the costs are not as prohibitive as you think. But you should also, one factor to look at is also the period of the trust, right? So we've had situations where trust is approaching like 80 years, 90 years, and the trust value per beneficiary, at that point in time may be insignificant, right? It may drop
That's
to
correct.
below 100,000 per beneficiary. And I think that's also something you should consider in your evaluation as to when the trust period should end?
Yeah. So I think the reality is that a properly drafted trust documentation will be drafted in such a manner whereby if the trust assets is insufficient or inadequate to maintain the trust, the trustees can exercise their discretion to actually distribute it to the beneficiaries. And therefore, you don't have a situation whereby the trustees are actually maintaining the trust just to earn their fees, because they are expected to, act in their fiduciary duty to take care of the beneficiaries. And if the trust doesn't make sense to continue, they should actually terminate and distribute to the beneficiaries at that point in time.
Okay, I'm going to take a few very quick but practical questions. How long typically does the probate process take in Singapore?
It's actually relatively fast, on average 3 to 6 months.
There is another important question around CPF, which was briefly mentioned in, I think, one of the opening sort of questions of the moderated session. So could you comment on what happens to CPF money in case of death?
I think Rina actually mentioned earlier that the best way to do it is by a CPF nomination. So you nominate your beneficiaries. If that's not done, it goes in accordance to your will. And if there's no will, by intestacy laws.
Yeah, so we do encourage that if you have CPF, the first thing to do is really to go online and do that nomination, save yourself that hassle, rather than leaving that to ambiguity.
Okay, we're going to go back to some of the questions around will, and particularly minor children. So could you comment on, any special considerations for minor children and, need for a guarantor? I think that's a question that's been raised by a few people. How does that get covered?
Sure. So I think especially if you have minor children, it's extremely important to have a will, because it also provides for how guardianship is done if you're no longer around, who would then become who you would pick as guardians of your children. On top of that, if you have minor children, then ideally you would also like to create some sort of trust arrangement for them if they are incapable of holding assets in their own names. So you need to provide for how they're taken care of financially, for their education and so on and so forth, until at least the age of majority.
There are a few questions around, wills to be made by a couple, husband and wife. So let me take this. Can there be a joint will for a couple? If most assets are joint assets, then how does the couple plan for them? And I'm going to insert, a small addendum to the question, because I think there is a great legislation in Singapore in terms of common disaster clause. Maybe you could touch upon that as well, because that's a complication that many may not be aware of.
So joint wills, we don't recommend it. We would recommend separate wills. Now, you need to deal with all your joint accounts. If most of your property is held as joint tenants, then it would pass automatically to your surviving spouse. But you would still need to mention in your will, if you are then the remaining surviving spouse, how those assets would be transferred. So it has to be provided for in the will. But again, a point to note is you can't sever the joint tenancy in your will. So if your your partner is still alive and it's a joint tenants holding, you can't in your will say that you're going to leave your share to a third person, even though it's a joint tenant account. I think that's a key point.
I think from a practical aspect, it's not ideal to have a joint will as well, because the will is not only to cover financial assets or property, it's also to cover personal effects. So I've mentioned earlier, it should talk about who your car goes to, who your jewelry goes to, who your watches goes to, right? So these are personal effects whereby it is not possible for you to put it in your joint will. So from a practical aspect, it is much better that husband and wife, they have their own individual will, but of course for commonly owned assets, to ensure that there's no ambiguity, they may want to say that for this particular asset, it goes to the other. But for the rest, you should be able to say, who do you want it to give it to?
I realized I didn't answer the second part of your question, which is what happens if there's a disaster and unfortunately two people, say a couple pass away at approximately the same time. Under Singapore law, if you are unable to determine who passes away first, it is assumed that the elder of the two is the one that has passed away first. And that's how the assets are distributed. So for example, husband and wife, if the husband is older, then his assets would be distributed in accordance with his will first. And then if he leaves a certain amount to his wife, then it is distributed secondly, in accordance with his wife's will. How we deal with this in practice is to draft in the will that a particular person only receives the assets if they survive him or her for more than X number of days. And if that doesn't happen, then alternate method of distribution.
Okay. There are a number of questions around the costs, again, for trusts. So I'm going to take a question that is probably the most comprehensive. How do you compare a will, trust, and a trust in terms of fees and charges?
So I think the reality is that in the example that Vigna touched on earlier, that what happens in a disaster, and if both husband and wife pass away at the same time, then how are those assets dealt with? Okay, so therefore, we have seen a lot of situations whereby the family has a sizable amount of assets, and therefore they feel that we do not want to leave it to ambiguity that if both passes away, then our children, who are essentially minors, would have to wait for that probate process to be completed before they can have access to liquidity. So the reality is that the cost of a trust is really the amount you pay to your trustees to ensure that this ambiguity is not there, to remove the need for probate for those assets, and to allow your children to have immediate access to those assets. Okay. And I think we also touched upon it earlier that we are not saying that if you have a trust, you don't have a will. We're saying that it is intended that these are tools that should work together. So you would have a trust to address liquidity concerns for your family. You will have a will to cover assets that doesn't need to be transferred immediately to your next of kin, but they should still be transferred at some point in time, and they could wait for that probate process. So there isn't you can't really put a cost to it in terms of, oh, I'm paying this for that particular purpose. It's more like you're actually paying something to get yourself, I would say, a peace of mind. And Vigna has also touched on earlier that there is a misconception that trust is very expensive, it will charge from a percentage of assets and so on and so forth. That's absolutely not true. Vigna has also mentioned that the starting cost for trust could be USD 5,000, and depending on the complexity of the assets and the responsibility of the trustees, then it adds on. But it's not add on based on the percentage fee. It's add on based on what the trustees feel their responsibility would be and price that responsibility into the fee. Okay. Now, in relation to wills, I've seen a question as well that talks about if I just do a will writing online, would that be sufficient? I guess the reality of the matter is that in the event if, number one, the will has to be witnessed, and in the event if your will ever get contested, who's going to act as the witness against that will in court? So therefore, it's quite important to get a proper professional to do it up for you, because you are actually putting in place a process, a procedure in terms of how your assets are to be distributed. And you do not want any ambiguity to that process. And therefore, I think a properly drafted will, written and witnessed by the right people, becomes very important from that perspective.
If I could add on to that, yeah. So I think it was mentioned that it is also possible in your will to have some sort of trust, right? But what happens then is that it is the executor of the trust, of the will, who will act so-called as the trustee. And that person may be connected in some ways to the beneficiaries, or may in fact be a beneficiary himself or herself. So if you want absolute comfort that the trustee, who has absolutely no personal connection or financial interest aside from the fixed fee that it's getting, if you want that peace of mind, then I think it's essential that you get a professional trustee which is licensed by MAS and periodically audited and has that degree of professional control. I think the other point which we may want to add on in terms of the differences between a will and a trust, aside from the skipping the probate process, secrecy, is also the instance where you may not want the entire assets to go to your beneficiary immediately, right? For example, you think that if your asset size is considerable and it's given to your beneficiaries at a relatively young age, perhaps they may not work, which is not your intention. You want them to have fulfilling lives before they get access to your funds. You want it to be periodic. I think that's one of the reasons why you have trust. Creditor protection as well. That's key. The moment, if you think that your beneficiaries may be embarking onto slightly risky business ventures, or it is quite ordinary in the course of their business to provide personal guarantees, then it actually makes sense that you have this pool of assets which are not considered their own assets. I was reading about, of course, I'm not involved in the case, but about how Anil Ambani is apparently not worth very much anymore because of his huge line of creditors and how his investments have dropped. So if you want to at least have some pool of money set aside as a security blanket for your next generation, it does make sense to put that in a trust.
Vigna, related to that, I think there is one question which really touches upon something similar. It says, what has been your experience in solutions that provide cash or income rather than transferring assets right away, particularly in the context of changing legal and sort of tax laws in the different jurisdictions?
Okay, so I think in terms of tax laws, it really varies from jurisdiction to jurisdiction, right? Some jurisdictions, if you transfer monies into a trust, there may be some sort of gift tax. If you're transferring immovable property while you're still alive, for example, in Singapore, there's stamp duty. But if you transfer property in your will, via your will into a trust, there's no stamp duty. That's from the Singapore perspective. You should also look at, in terms of some jurisdictions, you have forced heirship laws as well, which may dictate how particular assets are transferred. In Singapore, we have a specific clause that says we would not recognize forced heirship laws in a trust in relation to other jurisdictions. So that's also a relevant consideration.
And again, related to that one, given our audience, the role of the executor. Many in the audience may wish to appoint siblings, let's say, as executors of their wills, but siblings, could be staying in different jurisdictions or may hold different citizenship. Could you comment on any implications of the citizenship or the residence of the executor?
If it's an executor of a will, that shouldn't really have any sort of tax implications. Of course, if you are a beneficiary of a trust, or there could be tax implications when you receive the money. Generally, assets in a trust are not considered assets of the beneficiary if it's a discretionary trust, but they would likely be income tax considerations when they receive monies out of the trust. Then the question also is, in some instances, you can say that the receipt is out of the capital monies in the trust and not out of income. So the trustees would keep a very clear account as to what funds are capital and what funds are income, and whether the distribution is from capital and income.
So Deepika, just to touch on that, I think the reality is that when we are dealing with assets that are located in high tax jurisdictions, or if we are dealing with beneficiaries that are located in high tax jurisdictions, that is where I think the usage of a trust becomes even more relevant. For example, I see a question in relation to US assets. And the reality is that a lot of people don't realize that they may be Singapore residents, but they hold US assets. And in the event if something happens to them, they are still subject to US inheritance tax because they hold US assets. Okay. Whereas if these assets were held under the trust, then the trust would have acted as a barrier against inheritance tax in the US. So therefore, when we talk about setting up a trust, it is very relevant for us to consider, number one, of course, if there's any tax in transferring those assets into the trust, what's the best way to transfer it to minimize taxation, but also to think about that maybe doing this would minimize my potential inheritance tax on the value of the assets at the point when I demised. It is not uncommon as well in Singapore for us to see a lot of parents sending their children to the UK or the US or Australia or Canada for studies. And these countries are of high tax jurisdictions. But if you planned appropriately, the beneficiaries could potentially receive those distributions tax-free, rather than them having to pay tax on those assets. So it's about careful planning, and it's a situation whereby you need to have a constant discussion with your trustees in terms of your changes in your family circumstances, and make sure that all these tax obligations and tax changes are being addressed in the structure that you have set up.
What I've also seen, just to add on, is in relation to persons who have not been resident in India, right? And they are actually, I've seen this in relation to cases of non-Indian citizens, but who are looking at moving back to India, and how they have used, of course, if they move back without setting up a trust, once they become Indian resident, they're subject to worldwide taxation. But we've seen the use of trust being set up before they moved back to India. And the advice that we have also confirmed with Indian Council is that, if it's a discretionary trust, there are also non-Indian resident beneficiaries. That trust structure may work for that purpose as well. So that's a practical situation. We've seen it.
Okay. We will be reaching the top of the hour very soon. So I'm going to take some very quick questions in the interest of covering the most. Is it necessary to have a register of assets valid and maintained for the will to be valid? Does the will need to be registered itself in the, with the registrar of wills?
So in order for a will to be valid, it actually does not have to be registered. It is, registration is useful just so that your beneficiaries can find out whether or not you've done the will. So they can go to the will registry and check, have you done the will, and if so, where's the will kept, and who helped you prepare it. But it's not required in order for it to be valid. So if confidentiality is a key, you don't need to register it, but do let your beneficiaries know where the will is kept.
Okay. I think Reena briefly answered this question. There are a number of websites in Singapore offering online will making. So I think we've already addressed this, right?
Yeah. Just to touch on the part in terms of register of assets accompanying your will. The reality is that if you don't actually state where your assets are, I don't know if your executor of the estate knows which bank to go to or which property that you have that they need to actually unlock and unfreeze the value. So you may not want to put it in detail in your will, but you should have an annexure of your assets. So from a practical aspect, at least to let your executor know which bank to call in terms of trying to unlock your assets.
To add on, to your question, right? So one of my former associates actually set up an online will platform. It's called Willscraft, right? And I'm not an investor, so I have no interest in it. But I have spoken to him, and essentially, the target audience for these sort of businesses are really those individuals whose assets may not be that significant, and if it's just a couple 100,000 in assets, it may not justify incurring the legal expenditure to do a will. So I think we got to be quite careful as to what is being targeted by these automated platforms.
We still have a number of questions, so clearly there's a lot of interest, and we could potentially spend a lot of time discussing these. So I am actually, to conclude this discussion and to give us a way forward for addressing, the individual, the open items that many of the people individually have. I'm going to take up one question, which is, what are the next steps? How to proceed? Whom should I reach out to? So we will, there are a number of things that you could do. But we will, as follow up to this webinar, send you, of course, the recording of the webinar. We will also send, some of the contact names for, the panelists, the contact people representing the panelists who could help you with any additional questions that you may have. So they can be sort of taken up separately and offline, since we will not have time to cover all of them right now. We are at 12:02 now, so we will need to close the session. It's been, a very engaged sort of discussion from the side of the participants. I think we had great attendance and a lot of interest, particularly with some of the finer details on how to work out estate planning. There are plenty of misconceptions as well. Hopefully we clarified many of them. Reena and Vikna and the team at Bank of Singapore, who have helped us with this webinar together, on behalf of the audience and the IIMA Alumni Association of Singapore. I'd like to thank you for spending time with us, and we do hope that we can keep the conversation continued, after this. So our audience will have your details. Thank you very much. Yeah,
thank you very much.